Hello, everyone. I'm Dr. Akhila Basalalli. I'm an assistant professor at School of Legal Studies, CEERA-NLSIU University, Bangalore. In this session of Pan-India Legal Literacy and Legal Awareness Program conducted by CEERA-NLSIU under the aegis of Department of Justice, Ministry of Law and Justice, Government of India, I'll be talking about law relating to child labor in India. Now, the child labor as such has been a challenge to the nation for quite some time. Every 4 of 100 children that we see in India is the child labor. It could be in different forms. It could be as employed in construction sites. It could be as the agricultural labor. It could be as a helper in the restaurants or hotels or as domestic. So India has been constantly struggling with this social evil that is child labor. Now, with the state intervention and, of course, the collaboration of the civil society organizations, we have not altogether able to eradicate it, but we definitely have brought the numbers down greatly. So, which is why I thought just a glimpse of what exactly has been state intervention in terms of legislative framework was necessary. Now we see that India has consistently made efforts to eradicate this child labor, which is why a brief look into the legislative framework as well as what international commitments India has been a part to becomes necessary. Now it begins with the colonial legislations. There were 2 colonial legislations, one in the year 1933, which specifically prohibited the pledging of children as labor. That came in the year 1933 from the British administration. And the second legislation was the Employment of Children Act that specifically prohibited the child labor in hazardous occupations or hazardous processes. Now, post-independence period, the Indian Constitution itself provides the guarantee or it realizes the rights of the children with 2 specific articles within the fundamental rights, that is Article 24, which prohibits the labor of children within the age of 14 years in factories, mines, and hazardous employment. Along with that is Article 21A, which provides the free and compulsory education. Now, consistently, we see that the free and compulsory education often comes handy when we talk about prohibition of child labor, because within the very framework of child labor, we see how importance is attached to the education. Going further, within the directive principles of state policy, there are Articles 39 clause E, F, and Article 47, which are the directives to the state to facilitate the development of child in a healthy manner, to provide the nutrition that is required, and also realize that the growth of the child, the access of the child to all the essential requisites are important, and also to ensure that there is no abandonment of the child or abuse of the child. Going further, apart from this constitutional mandate that we have, the international law also recognizes that the child has a right to develop in a healthy manner. So these efforts came about in the year 1976 when the General Assembly adopted a resolution requiring the state parties to recognize the rights of the child. Subsequently, 3 years later, a particular year was called as International Year for Child. Bringing Indian activities in tune with the international developments, it was a very same year that the Ministry of Labor constituted a committee to look into this problem of child labor. The Gurupada Swami Committee in 1979 came out with 3 wonderful observations. First is, it talks about the nexus. It talks about the relationship between the poverty and the child labor. Further, it talks about how it is impossible for India to absolutely abolish child labor, which is why there is a need to regulate it. And third is, such a regulation can only happen with the multi-policy approach. So as a consequence to the observations of the committees, India enacts its Child Labor Prohibition and Regulation Act in the year 1986. And in the year 2016, there are a few amendments that have been brought to this particular legislation. It's also noteworthy that India has been a party to several international resolutions and also conventions. Few of them are from ILO, that is International Labour Organization, that talks about the minimum wages, minimum age, and also abolition of the worst forms of child labor. There is also one specific convention on child rights, that is the Convention of Child Rights in 1989. India is a ratified party to it. There is a particular article in this convention, that is Article 32, that talks about the importance of the child rights, particularly in terms of the child's rights against economic exploitation, which in other terms leads us directly to the child labor. Now, India does not hold any reservation to this particular provision, but it merely makes a declaration. It recognizes that this particular right against economic exploitation is a progressive right. And India right away can't bring this into action, which is why it promises that over the period of time, eventually India will make sure that there is a prohibition against this kind of economic exploitation. Now, after having this brief look into the legislative framework, let's ask a few questions as to who is the child, what kinds of labor is prohibited, what is the punishment that one can attract in case a person is employing the child, and what are the measures, what are the remedies that one can look for when there is a child or adolescent as a part of this particular labor. Now let's begin with the understanding of who is a child. Before that, the particular instrument that I'm going to talk about is the Child Labor Act of 1986, along with the amendments that was brought in 2016. Now, the very objective of these two enactments is twofold. One is it prohibits the engagement of children in all occupations. That is, the child cannot be permitted or the child cannot be employed in any of the occupations. That's the first objective. The second is, it doesn't stop at the child, but it goes ahead concerning the labor of the adolescents, saying that it shall prohibit the engagement of adolescents in the hazardous occupations and processes. So there is no general prohibition on adolescents who can be employed, but they may not be employed in the hazardous occupations or processes. Now, who is a child? The very legislation talks about the age within which, if a person's fall within that particular age, he or she will be called a child. That is Section 2, subclause 2, where a person who has not completed his age of 14 years or any other age that has been specified in the Right of Children to Free and Compulsory Education Act. Any person who is falling within the age group of 14 years, or if there is any other age that the Right to Education Act talks about, then such person shall be called as child. Now, I have already mentioned in my previous slide that the child labor has been closely associated with the Right to Education Act. Then the next question arises as to who is the adolescent. Now, adolescent is a person who has completed his age of 14 years, but has not completed the age of 18. So all the persons falling within the age group of 14 to 18 years are called as adolescents. Now, having understood who the child is and who the adolescent is, let's look at what kinds of child or adolescent labor is prohibited. Now, there's a general prohibition on children to be employed or permitted to work in any of the occupations or processes. There's a general prohibition that the child may not be or shall not be employed in any of the occupation or processes, but this comes with only two exceptions. A child can help his or her family or a family enterprise after the school hours or during the vacation. And such family enterprise or such work should not fall within the hazardous occupation or processes. What are the hazardous occupations or processes is something that has been listed in the Schedule 1 of this particular legislation. With the amendment that came in the year 2016, the schedule just has three areas. One is mines, inflammable substances or explosives, or hazardous processes, which gets defined in the Factory Act. Mines, inflammable substances or explosives that we know. What are hazardous processes is something that we have to refer to Factories Act within the definition of clause CB. Now there, it includes or it involves all kinds of activities which create some kind of impairment to the health or which pollutes the environment. Any process, any occupation that creates impairment to the health or it pollutes the environment gets to be called as hazardous processes. A child may help his family, her family, or the family enterprise only when the occupation does not fall within the schedule of this particular act that talks about 3 different occupations or processes. Apart from that, there is also no prohibition on the child if he or she wants to work as an artist in any audiovisual entertainment industry, advertisements, films, serials, television, entertainment, or sports. The only limitation to this particular clause is a child shall not work in circus. And this came as a consequence of a particular case, that is Bachpan Bachao Andolan in the year 2011, where 18 girls were rescued from the circus and they were physically, sexually, mentally abused. Now, this came specifically explicitly as a prohibition post Bachpan Bachao Andolan case. So the entertainment industry, as an artist, a child is allowed to work, but not in circus. Whatsoever is the help that the child renders to his or her family or the family enterprise or as an artist shall not have any effect on the education of the child. So consistently, there has been an effort to promote education as per Right to Education Act. Now, as to who can be the family, because it's often tricky that a person calls himself or herself to be a family, but will be an extended relative. So there's a limitation within this very act as to who can be the family. Now, the child's mother, father, brother, sister, or father, sister, or brother, which means the paternal uncle or aunt and the maternal uncle or aunt are the only people who fall within the category of family where the child can help. Going further is adolescent. Now, adolescent shall not be employed or permitted to work in any of the hazardous occupations or processes. I've already discussed as to what we mean by hazardous occupations or processes, for which we have to look at schedule to this particular act. The employment or the occupation of the adolescents are further regulated with regard to the amount of work, the hours that they work, and the period that they work. Now, at any given point of day, the maximum hours that the adolescent is allowed to be working is 6 hours, where there will be an interval after every 3 hours. That is an interval between the 6 hours, right? Third hour. Adolescents shall also not work between the time frame that is from 7 p.m. to 8 a.m. There shall not be overtime work, and there shall always be a weekly holiday. The central government also sets up this particular committee, that is technically advisory committee, that shall look into what kinds of additions or deletions has to happen to the Schedule 1 with regard to calling what occupations and processes are hazardous. And also, there shall be the rules, inspections with regard to how safe and healthy are the working premises. If the sanitation facilities are provided, if the occupation is hazardous or not, if the family enterprise is really a family according to this legislation, so on and so forth, there shall be inspections, there shall be visits with regard to the health and safety aspects. Now, the next question arises, now that we have understood who the child is, who an adolescent is, what kind of activities are prohibited, what are regulated, what happens, what one should do if we have to report a case. Suppose we encounter a situation of child labor, what do we do then? Then there are 4 means that a person or any one of us can resort to. First is, there is a child line, India Foundation helpline. There is a helpline. When you dial 1098, you will be reached to a call center that is particularly established to look at the problem of child labor. A person, a trained technician will attend your call, and taking the note of the premise or the area, the district that you fall or a child falls within, there shall be the field a party who generally will be the civil society organization along with the help of the police officials. Within few hours after the complaint has been made, the attempt will be made to rescue the child. And it's not just left there. Post intervention, after the child is rescued, the concerned party has to report back to this helpline as to what efforts were taken, how it has basically been materialized. So one can always call up 10898, which is a number that reaches to Childline India Foundation. The next is Pencil Portal, the platform for effective enforcement for no child labor. And now this is an online platform where you can register a complaint. So this shall be something that shall involve the district authorities, the civil society organization, and the public, who will take the joint efforts to rescue a child who is working as a child labor. And the third option is going to a police station, the nearest police station within which that particular establishment or a house or where the child has been employed, to what jurisdiction that particular child falls. You can make a complaint in the police station. The lodging the complaint, filing of an FIR will be the process forward. And the fourth option is you can directly make a complaint to the chairperson of the National Commission for Protection of Child Rights. Or within that very same portal, there is also e-Bal Nidan, where you can just put across your complaint. The suo motu action will be taken by the National Commission for Protection of Child Rights, and they shall initiate the proceeding thereafter. So these are the four options that one may go to in case of you encountering with the child. Now, what is the punishment? What happens to the person who has been employing or permitting the child? Now, the violation of what exactly is prohibited that falls within the section 3 and 3A of this particular act, there is an imprisonment that shall be for 6 months. It shall extend to the period of 2 years. There is also the fine of 20,000 to 50,000 rupees or both. Now, often the question arises, will the parents and the guardians also be treated on the same platform? Will they be treated on par with the other employers? Now, the parents and the guardians will not be punished at the first instance, but subsequently they may have to face the charges, which shall be the fine that may extend to 10,000 rupees. But for other people who have been employed or permitting the adolescent to work in the hazardous occupation, or who has been employing the child, except for the exceptions that have been stated in that particular section, there is a punishment that shall be for the period of 6 months to 2 years, fine that may extend to 50,000 rupees or both. Now, commission of a like offense, commission of a similar offense can again entail the imprisonment of 1 to 3 years. However, it is important to note that these offenses are compoundable. That is to say, you can reach a settlement and not proceed with the case as such. Now, another very, very important area is what are the remedies that are available for the child? Because we saw that through those helplines, the child may be rescued. But what happens after that? Because it's also very important that there is a proper channel through which the child is put back to the schooling, or the child basically copes up with the resettlement. Now, there is this board that is constituted by this act, which is called as the Child and Adolescent Labor Rehabilitation Fund. So to this fund, the fine that is being released by the employer, the fine that is collected by the employer for having violated section 3, will be credited to the account that has been initiated within this Child and Adolescent Labor Rehabilitation Fund. Along with the fine that is credited to the child's or the adolescent's account, the government shall also credit 15,000 rupees to each one of those child or adolescent's account. Now, after the amount has been credited, the interest that it generates shall be paid to the child or adolescent for their benefit. That is one part of it. The second part of it is, what about the rehabilitation measures? Now, as a part of rehabilitation measures, the Ministry of Labour has actually started a scheme, that is National Child Labour Project Scheme. This particular scheme is targeted to rehabilitate the children falling within the age group of 9 to 14. There are special trainings centers that are established the separate schools that are established. To this day, there are about 6,000 of the special schools that are established through this particular scheme, where they provide some kind of specialized training for these children. That includes education, apart from their education, the vocational trainings, the midday meals, a stipend of about 150 rupees is credited every month, and the healthcare benefits are also being provided to the children and adolescents who have been rescued. This more or less now is absorbed into the Samagra Shiksha Abhiyan scheme that we have created. But the remediation, the rehabilitation process are pretty beautifully laid out so that the child is properly reset. Now, the provision also provides a few, the particular act also provides a few provisions for the inspection and monitoring. Now, the district magistrate is responsible to ensure that the objective of this act and the provisions of this act are properly implemented. Apart from the act, apart from this particular monitoring, there shall also be inspection. The officers shall be nominated, and they would be asked to inspect if the provisions of this act are properly implemented. For instance, the register is to be kept where the adolescents are employed in non-hazardous activities as to the number of hours, when are the weekly holidays, how many number of adolescents work, and all the other requirements of their overtime, that it should not be overtime if the leisure is provided, what are the sanitary conditions, the health benefits, etc. All of these records shall be subject to inspection. The inspection also involves looking at the working environments, looking at if the child really is helping the family enterprise or is it just a mockery. The inspector also would be involved in determining the age of the child in case there is a dispute. So you have the whole state mechanization structured in such a way that there is proper inspection and monitoring. Now, when we look at all these provisions concerning who the child is, what are the prohibited activities, what do you do in case there is when you face a situation of child labor, what are the punishment, what are the remedies that are available, we see that there is law in place, starting from the constitutional mandate to the specific legislations that have been made. We see that all of these are properly structured. But this is not merely enough if we have to combat the problems such as child labor. So it requires that the society comes together, we join hands to ensure that it is eradicated. And I strongly urge that we all need to respond and just not turn a blind eye towards it. Having said this, I hope that this video has sensitized all of us and it has served the desired objective, that is creating legal literacy concerning child labor. I thank Professor CEERA Bhatt, Mr. Geller, and his team of NLSIU CEERA for giving me this opportunity to do my small bit in such a noble cause. Thank you very much.